Hi there, I'm Professor Blackmore, and I want to welcome you to ProfessorBlackmore.com, where our goal is to empower results through real productivity. And if you haven't been here before, I want to ask that you please subscribe to my YouTube channel and click the bell so you'll be notified whenever I post new videos. And please also follow me on TikTok and Instagram. And today, I want to talk to you about the homicide, more specifically, the involuntary manslaughter charges brought against James and Jennifer Crumbley by the Oakland County, Michigan prosecutor. And as you know, last week, James and Jennifer Crumbley's son, Ethan Crumbley, carried a firearm to Oxford High School in Oakland County, Michigan, and killed 4 people and caused many other people there to suffer serious physical and emotional injuries. And this is a sad set of circumstances. And I want to say at the beginning that many of you will post comments in the comment section of this video alerting me to things you've heard on social media. And believe me when I tell you that I've seen and heard all of these things, but the actual practice of law in the pursuit of justice just does not work that way by social media facts. Everything you think you know will never see the light of day in a courtroom at the time of trial. All of those things that you've seen on social media and all of the things that you think you know about the case will never see the light of day in the courtroom at the time of trial. So I avoid discussing that type of information because I'm trying to communicate facts based on the manner in which things actually happen throughout the pretrial and trial stages of a case. And please believe me when I say that I don't have an agenda in favor of any one of the players, against anyone, or for anyone. I'm just going to give you the facts as I know them, and I'm going to give you my objective opinion. It's not based on anything other than the facts and how they will be applied to the law at the time of trial. Now, there are just so many mixed up facts that have been spread far and wide about this case on social media and the internet. And the people spreading what they think are objective facts about the case don't know what a person knew when one action took place, and they make everybody else think that the person carrying out the act did in fact know that the other facts took place when none of us know, and as such, we should not give our opinion on it. So I'm going to go step by step, and I want to try to go through what I've actually seen take place. And so I'm going to begin with a brief timeline. Now, on November 26, James Crumbley purchased a firearm. And the facts will show that he took his son Ethan Crumbley with him to the gun store to purchase that gun. On November 26th, the child, Ethan Crumbley, posted photos of the gun on his social media with the text that read the words, quote, "Just got my new beauty today, Sig Sauer 9mm. Then on November 27th, the mother posted the following text on social media. Quote, "Mom and Son Day, testing out new Christmas present." Now, everyone is assuming she meant the gun, and maybe she was, but I'm not going to make that assumption because at this particular point in time, I have no facts that have given me any information to believe that when she said Christmas present, she meant the gun. She could have just said the gun, but that's not what she said. So we really just cannot assume that she meant the gun. After the purchase of the gun on 2 separate occasions, on 2 consecutive days, the school administration attempts to contact the parents. On November 29th, a teacher noticed that the child was browsing the internet on his phone, looking for ammunition. And on this occasion, the school contacts the parents, but they're unable to contact them. Nevertheless, the school has a meeting with the child. Now, the prosecutor alleges that the mother sent the following text message to the child. Quote, LOL, I'm not mad at you. You have to learn not to get caught. End quote. Now, there are no facts that provide information about exactly when this text message was sent to the child. Then on November the 30th, which is the morning of the shooting, another teacher observed the child drawing a disturbing drawing of a semi-automatic handgun pointing at the words, quote, "The thoughts won't stop. Help me," end quote. In addition, the note included a section with a drawing of a bullet with the words, quote, "Blood everywhere." So the school administration calls the parents in for a meeting, and the parents do in fact attend a meeting that morning at Oxford High School along with the child. Now, along the way in both of these meetings, in connection with the school's restorative approach to discipline, a school counselor was involved. And during that November 30th meeting, it is my understanding that the parents never mentioned the gun. And while we all now know in hindsight about the child's November 26th social media post with the pictures of the gun, there are no facts to establish that the school administration ever saw that post at the time of their November 29th and November 30th meetings. And there are no substantiated facts that I've seen that reflect that the parents knew about that post. The school administration asked the parents to have the child meet with a therapist within 48 hours, and the child was released back to class. So the parents leave the school, and in the afternoon, the parents hear about the shooting at their child's school. Now, I can only imagine that it was then that the parents snapped. 1:22 p.m., upon hearing the news about the school shooting, the child's mother sends a text message to him that reads, "Ethan, don't do it." But by then, it had already been done. Notwithstanding the unsubstantiated social media facts, according to the parent's attorney, the gun was locked up. And so I'm going to go ahead and assume that that is accurate information. I do not know the specifics, but imagine if you're at work and you're this child's father. You race home upon hearing this news to confirm whether or not your gun is where you left it. Well, upon discovering that the gun was not where he left it, the father frantically calls 911 at 1:37 p.m. Now, after all of this, obviously, the sheriff searches the parents' home and other personal property, and the prosecutor charges the child as an adult with homicide and terrorism charges. In doing so, she also publicly announces that she's going to charge the parents as well. Now, if you're the parents of this child, what do? If you have an entire town that hates your guts, can you just stay at your own home? Now, I do not have any specific facts about this particular point, but imagine that your child left home one morning and without any notice, you realize the 4 other children left home and will never return home or anywhere else on this earth for that matter. And your child will never return home, and the state prison will be his new address probably forever. The prosecutor gets on TV in a press conference and makes good on her threat to charge your child as an adult, and she also announces that she's also going to charge you as the parents. And so I ask you again, what do? How many death threats do you think those parents received before this announcement on television by the prosecutor? Can you imagine how many more they would start to receive after the prosecutor's public announcement? So I don't have any direct facts, but I'm only using my own 20 years of law practice as an example. And so it seems that the parents go out and they retain an attorney. Now, once retained, I would probably give them some instructions, and we would get a bail bondsman ready so that I could work with the prosecutor so that they could turn themselves in safely. But after the attorneys do that, what do you do now as the parents? Do you just go back home? We all know that they would never get any peace in that home from the media or from any other threats of violence that they may have been receiving. So it seems they left the county seeking a safe place to await further instructions from the attorney. Instead of working with the sheriff's office and the defense attorneys, who did make numerous attempts to contact the prosecutor, On November the 3rd, she instead conducts a surprise press conference announcing the involuntary manslaughter charges against the parents. And so she does in fact announce 4 separate counts of involuntary manslaughter against each parent. And in the background, within that filing, there's also an arraignment that's set for 4 p.m. that afternoon. But this is not one of the things that is announced during her press conference. Now, I know from my own personal experience that it would be customary for the attorney to place a courtesy call to the attorneys to let them know that the arraignment is at 4 p.m. so that they can bring their clients in so that they can turn themselves in. But the prosecutor does not make any such attempt to contact the attorneys, even just to let them know that the arraignment is set for 4 p.m. that same day. Now again, I don't have any substantiated facts about the following, but based on how it works in real life, the parents are already wherever they were awaiting further instructions from the attorney. The attorneys are sure they're going to hear from the prosecutor, letting them know about the time of the arraignment because, again, that's customary. But not hearing from the prosecutor, they are assuming the arraignment had not yet been set. So they did what attorneys do and they filed a notice of appearance with the court so that they would later be notified of any such setting. But the defense attorneys never received any such notification from anybody. Now, in addition, in order to file the charges, the prosecutor went before the judge that morning and she presented the detective's affidavit swearing to the allegations in the information or the criminal complaint. But somehow or another, the detective does not notify the sheriff, and the prosecutor does not notify the sheriff either. Everybody is just flapping in the wind, thinking that somebody else is going to get in touch with them, and no one does. The problem is that everybody is on TV doing TV interviews. And in the meantime, everybody is led to believe that the parents fled and are fugitives in hiding when these people are scared for their lives and would probably welcome the security of the sheriff's department. So we have, in my opinion, this fake manhunt for parents creating a national media and social media freakout. Luckily, no one ended up dead, but it seems that everybody took a normal everyday occurrence of pressing charges and turned it into a very dangerous manhunt that ends in the early morning hours of December the 4th, which is Saturday. Another thing of note that I found very interesting is that on that Saturday morning, December the 4th, the actual judge assigned to the case makes sure she's present for the nationally televised Zoom meeting arraignment. Now, normally in most jurisdictions, a weekend judge or a judge on call would do after hours and weekend or holiday arraignments. But nope, not in this case. The judge assigned to the actual case is present on the bench and sets bail in the amount of $500,000, all cash only, no bond for each one of the parents. And she bases this decision on the fake fugitive scenario created by the prosecutor. Now again, I have no interest. I do not know these parents. I'm just telling you how I see this. I don't have anything against or for anybody. But before I go into my opinion about the charges, let me say that these parents may be incredibly stupid people. Clearly, the mother wanted to be the child's friend. And in my 20 years of criminal and juvenile law, in addition to some other areas, it is my opinion that you just can't play patty cake with children. This child has some serious issues. And in my opinion, the parents were not aware. And I even saw a local news interview of a child at that same school. And that child stated that the Crumbley's child had been bullied. The child in that interview had heard on social media that something was going to be afoot, and he stayed home that day from school. So I'm clear that that Crumbley child, Ethan Crumbley, had some serious issues. And these issues were tremendously exacerbated by the father purchasing a gun. Yes, the parents did some incredibly stupid things, but stupid does not equal criminal. Now, I admit, I do not have the intel that the prosecutor has after executing numerous warrants and subpoenas, but she is not exact about some of the facts that she puts out. She throws facts around out of order, so you'll think the left hand knows what the right hand is doing, when in fact one person or entity probably didn't know. For example, in her press conference, she stated that at the meeting at the school on the morning of December the 30th, that the parents did not ask Ethan if he had his gun. So if you look up the records indicated that the father purchased the gun. So how she's calling the gun the child's gun, what she's doing is she is taking the child's November the 26th social media post in which he states, "Just got my new beauty today, period, 6 hour, 9mm, end quote. And she's taken the mother's November 27th social media post in which she states, "Mom and Sunday, testing out his new Christmas present." And the prosecutor puts these two things together to mean that the gun belongs to the child. She spreads this information when it is likely not true, and we just don't have any facts that can substantiate it. The gun was purchased by the father. And so the prosecutor uses these broken facts to allege that the parents didn't ask the child if he had the gun, when we don't know if they did or did not ask. For whatever reason, they were clueless about this child's mental state and seemingly didn't think he'd take the gun, because apparently they thought they'd done a good job of locking the gun up. And so I'll state again, we don't know if the parents or anyone from the school administration ever saw the child's social media post with the pictures of the newly purchased gun. So now, with all of this in mind, if you've been following my channel, you'll know that the first thing that I'm going to do is to go to the pattern jury instruction that will be used by the jury at the time of trial to establish what the prosecutor would have to prove at the time of trial. And I'm saying right off the top, unless these charges are downgraded, I cannot see how the prosecutor will be able to prove involuntary manslaughter beyond a reasonable doubt for 3 reasons. And all of these following 3 things must be proved beyond a reasonable doubt at the time of trial. And the first thing is causation. The jury will receive the following instruction. Quote, "There may be more than one cause of death, but it's not enough that the defendant's act made it possible for the death to occur. In order to find that the death of the person was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act." End quote. So I don't see how the prosecutor will be able to find any act of the parents that actually caused the death of anybody. The discrete act of buying a gun does not cause death. Until you fire that gun, causing a bullet to strike someone, you haven't done anything that draws a clear causal line to the death of anyone. And so it follows that the act of leaving a gun unlocked does not and did not cause the death of anyone. Even if it did create the requisite causal link, you'd have to assume that the parents intentionally left the gun unlocked, and we have no facts about that. And I think it would be very difficult to prove that any facts like that existed. Now, the second thing is gross negligence, which is an incredibly high bar. The jury will be instructed as follows. Quote, "Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or in failure to act. In order to find that the defendant was grossly negligent, you must find each of the following 3 things, and you must find these 3 things beyond a reasonable doubt. First, that the defendant knew of the danger to another, that is, he or she knew there was a situation that required him or her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury." End quote. Now, I think the prosecutor incorrectly is just reading this and trying to make it be what she wants it to be. But the parents were clearly clueless about the dangerous nature of their own son. I think the facts would bear that out. They had no clue, and if they did, they may not have purchased that gun. But we don't know, and you'd have to know, because you have to prove this beyond a reasonable doubt. You would have to prove that they did in fact know how sick their child was and still went out and bought a gun and willfully left the gun unlocked knowing that he had these thoughts. But don't forget, even if you reach this standard, even if you're able to meet each one of these elements beyond a reasonable doubt, we still have no established causal connection. And we don't have the next thing that I'm going to talk about, which is also necessary. So you need that causal link that I mentioned first. You need to understand and be able to meet the specific definition of gross negligence. And then that brings me to the third thing, which is a requisite culpable mental state. And the jury will be instructed on this as follows. And I'm quoting exactly as it would be printed on that jury instruction reading. You have heard evidence concerning the defendant's mental condition at the time of the alleged crime. It is not enough that the defendant did an act that caused death. In addition to this, the defendant must have had a certain state of mind when he or she did that act. You have a reasonable doubt about whether the defendant had the required state of mind at the time of the alleged crime, you must find the defendant not guilty. End quote. I just don't see how the prosecutor can come anywhere within the purview of meeting all of these requirements, which she'll need to establish each and every one of them beyond a reasonable doubt at the time of trial. So then one would ask, why did we need to create all of the hysteria of hunting the parents down in a nationwide manhunt by the U.S. Marshal Service, even causing the judge to set bail in the amount of $500,000 cash only, no bond? So the parents can't even post a bail bond for this bail. Well, I don't know what the reason is, but as always, we'll have to wait to see what will happen in this unfortunate case. Again, these parents, in my opinion, are incredibly stupid, but I don't see criminality in any of their actions. Now, where I come from, judges like catfight cases. That's what this is. This is a catfight case. Okay, you got, and judges, they like to create catfight cases. Sometimes they'll appoint, women on one side, so they'll have women on the other side, and so we'll have a catfight. This case with this prosecutor and these attorneys for the parents is a catfight. And so we'll have to see who ends up on top in the end. What I do know is that the prosecutor would have a tough time proving the requisite culpable state of mind for any crime associated with this unfortunate set of circumstances. What do you think? If you agree or disagree with my analysis, please leave your comments in the comments section of this video. In the meantime, if you've enjoyed this video, please give me a big thumbs up. And please also subscribe to my YouTube channel and click the bell so you'll be notified whenever I post new videos. And please also follow me on TikTok and Instagram.